Lauren, thank you so much for joining us here today. If you're watching this on YouTube, make sure you hit the subscribe button. We'll have all kinds of content like this that you'll get to see. Lauren, can I pass over to you for an intro, please?
Yeah, great. So, hi everyone. I'm glad to know that there are so many people interested in geeking out on food label compliance. Um, my name is Lauren Handel. I have a small law firm called Handel Food Law that focuses exclusively on food and beverage businesses. Regulatory compliance is a large part of what I do, but I also do other kind of small business, general legal counsel work. Today, we're going to focus exclusively on food label compliance. I do need to give quick disclaimer. This is for general information purposes, not specific legal advice. If you would like to hire me, you'll have to actually hire me. I'm not yet your lawyer unless you happen to be one of my clients. So to get started, I have a lot of material. We could spend a couple days probably going over food labeling compliance, but we will touch on as much of it as possible and hopefully leave some room for questions. And Daniel will hopefully interject with some questions. But let's just start. Hopefully you're here, you already know why this matters. And Daniel touched on this. Why does label compliance matter? Well, if your labels are not compliant, there is a risk of regulatory enforcement, of course, that a federal regulator or a state regulator could come after you, require you to make changes to the label. In all honesty, that is not a very high risk for most issues because there's just not the bandwidth in the agencies to be out policing the labeling rules. So I always say this to people when they tell me that they see their competitors making certain kinds of claims or doing other things that are non-compliant. You cannot look to the marketplace for evidence of what the rules are because there is a lot of non-compliance just because the rules are not very strictly enforced by the government. There is also the risk for certain labeling issues, especially failure to disclose an allergen, of having to do a recall, which is the most common reason for a recall and is a huge problem. There's also the risk of getting sued, which has been alluded to, and there are a very aggressive set of plaintiffs' lawyers who are filling in the gaps left by the regulators, looking for non-compliance, looking for anything that's arguably false or misleading about labeling and advertising of food, and they do sue and threaten to sue and look to settle those cases, but will fight them if they have to. And then there's also customer relations problems. So partly because of the threat of lawsuits, increasingly wholesale buyers, retailers are scrutinizing labels, asking for substantiation of claims. There's also consumer relations problems if they find out that there's something that's deceptive about your label. And all of this can cost you money and can harm your brand and your business. And so it's always cheaper to avoid the problems than to deal with them later. So, overview of who regulates labeling and advertising of food and beverages. We have a multi-tier system with federal regulation and state regulation. For the most part, we're going to talk about FDA regulation today. The Food and Drug Administration has general responsibility for the labeling of food and beverages, and that includes dietary supplements. But there is delegated authority to the U.S. Department of Agriculture, which has primary responsibility for meat, poultry, egg products, certain kinds of fish. USDA also has other types of labeling rules, such as country of origin labeling rules for certain commodities like produce, the organic program labeling rules, and the bioengineered food disclosure standard. CTB regulates labeling of alcoholic beverages, as do the states. Customs and Border Protection has requirements for country of origin labeling on imports. And the Federal Trade Commission is the federal agency with overall responsibility for truth in advertising and consumer protection. At the state level, there are some additional state labeling requirements in some state laws. For the most part, the states are enforcing federal labeling regulations, but states also have other consumer protection laws to prevent against deceptive trade practices, and that's the basis under which most of the class action litigation is brought. And which brings us to the litigation. So courts and lawyers are not regulators, but litigation is used essentially as a regulatory tool. The plaintiffs' lawyers, and they could be class action plaintiffs representing a class of consumers. They could also be plaintiffs representing advocacy groups, public interest groups, but it also could be lawsuits brought by competitors who could allege that if there's something false or misleading about your labeling, that that's a form of unfair competition. So the basic concept in labeling regulation is called misbranding, right? There is a prohibition against misbranding. It's illegal. It's actually a crime to misbrand a food or to sell a food that is misbranded. And there are different forms of misbranding under the law. The first is kind of the most obvious. It's a label that's false or misleading in some way. That can be because there are express statements on the label or images that are false or that create a misleading impression. It can also be implicit messages, so maybe not the exact words that are said, but the implied message behind them or the net impression of the messaging. And then it also can be the failure to disclose, the omission of facts that consumers would find important or material to their purchasing decisions. Misbranding, another form of misbranding, it has to do with mostly the shape and size of a container that can be misleading as to the fill of it, how much contents are actually in that container. It's called slack fill. Then there's also kind of a technical version of misbranding. So any violation of the rules, the regulations for food labeling is considered a form of misbranding. So even if a label is not false or misleading in some way, if it's missing information that's required by the rules, or if it has an improper statement of identity, or it is making a nutrient content claim in a way that's non-compliant, because of that technical non-compliance, that is a form of misbranding. So just quickly to go over the rules about what's required. And these are the things that are generally required for all food and beverage labels. For certain kinds of products, there are additional things that are required, but a statement of identity. So what is this product that's in a package that consumers can't see what's in the package? It's the name of the food, which if there is a defined food standard, that's the name to use, like ketchup. Or if there is no such defined food standard, which is most foods, it's the common or usual name of the food. And if there is no, widely accepted common or usual name of the food, it's an appropriately descriptive name. Net quantity of contents. So this is the net weight or volume of what's inside the package. A nutrition panel or supplement facts panel. The ingredient declaration, which lists all of the intentionally added ingredients, including sub-ingredients, by their common names in descending weight order. Major food allergens, if there are any, have to be disclosed. And then the identification by name and address of the manufacturer or distributor of the product. I included this rule. This is a super technical rule about characterizing flavors, but I include it because it is a litigation trap for the unwary. If you have a product that is flavored, meaning it gets some of its flavor from a flavoring, a natural flavor or an artificial flavor, and not strictly from the food that is represented as the characterizing flavor, there are particular rules about what you have to say to describe that flavor. So this example, the characterizing flavor is lemon. So a characterizing flavor is whatever you are representing the product tastes like, whatever food you say it tastes like. So commonly an issue with beverages, with confections, ice cream. If some of that flavor is coming from an additive, the word flavored is required. If that additive is derives the flavor in part from something other than the named food. So in the industry, these are called WONF flavors. Then the language flavored with other natural flavors is required, assuming that was a natural flavor. So in this case, some of it comes from lemon, but there are other natural sources that are reinforcing or mimicking the lemon flavor. And here's the part that people often are surprised by. If none of the flavor comes from the named food, even if all of the sources are natural, the flavoring may qualify as a natural flavor, and yet the rule requires the product to be labeled artificially flavored. I often see this problem that brand owners come to me, formulation is complete, they're ready to make a product, they have a draft label. I look at the flavor specs and tell them they're required to label this as artificially flavored, which of course no one wants to do. And that would generally require a reformulation to avoid that issue. General rules about claims. So shifting over from required content to claims that you may want to make about your product to let consumers know what differentiates it from other products and makes it better. Some general principles. When I'm talking about a claim, I'm talking about a statement of fact. It's something that could be proven true or false, not a statement of opinion or how it feels or how it tastes or what's considered puffery, like a gross exaggeration that no one would believe to be a statement of fact. If you're making a factual claim, you have to have substantiation for it. In most cases, no one's ever going to ask you for that substantiation, but legally you're required to have it before you make the claim. If there is a regulation that applies, and so we're talking mostly about FDA regulations, the claim can be made only in accordance with those rules. So if it's regulated territory, you need to know what the rules are and make sure that your product qualifies for the claim, you're using any required language. If there is an additional disclosure required, that you're doing that. Claims about components, which could be, let's say you want to make a claim about a nutrient or an ingredient in the product rather than the product as a whole. Those claims are generally just considered implied claims about the product as a whole, at least in the context of labeling, somewhat more flexibility in the context of advertising. But on a product label, if you want to say that an ingredient is a good source of antioxidants, that's a claim about the finished product as a whole legally. And if the finished product doesn't qualify for the claim, then you can't make that claim. And then last, you may have a statement that you want to make that is literally true. If we take it in isolation, you could prove it is true. And yet, there still may be risk because the overall impression of the labeling, that claim in conjunction with other claims, in conjunction with images on the label, could still create a misleading message. And so you always have to think about the overall impression that consumers are going to take away from the labeling, and is that supported and truthful and not misleading? So some examples of regulated claims. Nutrient content claims. We see these everywhere. And I just gave an example here. High fiber is a nutrient content claim. So is 7 grams of protein. I see some confusion about that sometimes people think that if I just state the amount of a nutrient, that that's not a nutrient content claim. That's wrong. Any statement that you make outside of the nutrition facts panel that states or characterizes the level or amount of a nutrient in the product is a nutrient content claim. And there are very specific detailed regulations about these kinds of claims. You can only make a nutrient content claim if it's authorized in the regulations. So if you go to those rules and you don't see a definition or a specific language authorizing the claim, you're not allowed under FDA rules to make the claim. There are certain defined terms, and I'll go over some of those, but there are certain defined terms to use, like high or low, and you have to use those words and not other words and meet the required criteria for those definitions. As I mentioned, you can state the amount, such as the number of grams of a nutrient. That is a nutrient content claim, but you're allowed to do that generally as long as you don't add other language that characterizes that level, like only 3 grams of fat, which implies that's low in fat. And then sometimes additional disclosures are required. So there are thresholds, for example, in the rules on nutrient content claims for levels of total fat, saturated fat, cholesterol, and sodium. And if you are over those, anytime you make a nutrient content claim, you have to add a disclosure next to that claim saying, see the nutrition information for X content, whichever nutrients are over the threshold level. So here's some definitions in the rules. There are others, but these are kind of common ones. Um, Good source contains or provides 10 to 19% of daily value. Just to explain what this is measured, the basis on which this is measured is usually the reference amount customarily consumed. So there is a rule, it's called the RACC, R-A-C-C. There is a rule that establishes a reference amount, which is considered to be the amount consumers ordinarily would eat in one occasion for different categories of foods. That is different from serving size on the label, although it is the basis by which you figure out what the serving size should be. But to standardize the meaning of these nutrient content claims, for the most part, they are measured by percent daily value per rack, not per labeled serving. Sometimes it's both rack and labeled serving. But good source contains, provides, those are all allowable terms for a nutrient within 10 to 19% of daily value. Rich in, high in, excellent source is 20% or more daily value. Then there are comparative claims. So if you want to say that your product has more or plus or added or extra, it has to have at least 10% more daily value than an appropriate reference food. And there are rules about how you choose which foods you compare to. But that's the definition, at least 10% more. The other way to compare is that you have less, fewer, or reduced, and that would be at least 25% less of the nutrient than an appropriate reference food. Free claims with respect to nutrients are the amount that you're allowed in the nutrition facts panel to declare as zero for calories, fat, cholesterol, sodium, and sugar. Low is defined at certain specific levels for calories, fat, cholesterol, and sodium. Importantly, there is no definition of low sugar or low carbohydrates, and therefore those claims are not allowed. I wanted to spend a little time on protein claims because this is has been for a while a significant litigation risk, and it's definitely not going away, especially since there are so many more protein claims out there, and there's a lot of marketing around protein content these days, right? So if this is you, you want to make sure you do this right because it is something that plaintiffs' lawyers are looking for. If you make a claim about protein, and so in this example, and this is an example of an actual lawsuit that was filed recently and is pending right now. Overnight oats, 15 grams of protein. You already know that's a protein claim. If you make this claim about protein, then you are required to include in the nutrition facts panel the percent daily value for protein. Without a protein claim, that's not normally required. And so often food labels will not include percent daily value for protein. So some of the litigation has been about products that just failed to include any percent daily value for protein when they made a protein claim. That's one problem. Another problem, and that's the case in this overnight oats product lawsuit, is that there was a percent daily value, but the plaintiffs allege it's incorrect, that it overstates the actual percent daily value because it wasn't adjusted for PDCAS. So this gets pretty technical. What you need to know is that not all proteins are the same. And so figuring out percent daily value for protein is not as simple as just taking 15 grams of protein divided by 50 grams, which is the recommended daily value, because some proteins, especially plant-based proteins, have different amino acid profiles and are not as digestible or not as readily available in the body. And so to figure this out, you generally need a lab to do this PDCAS analysis to, first of all, measure protein content in the product, and then do the PDCAS analysis to figure out how you need to adjust or correct the percent daily value to account for the protein quality. Healthy is an implied nutrient content claim. So people are often surprised if they're not familiar with FDA rules to know that the word healthy and variants of that term, so health, healthful, healthier, healthiest, all of those variations of that term, if used in conjunction with other statements about nutrition or ingredients on the label, is considered an implied nutrient content claim. Now, if you use a completely separate context, like we support a healthy planet, well, then that's not a nutrient content claim. But if you are representing that the product or its ingredients are healthy because of nutrition, or you make other nutrient content claims or claims about nutrition on the label where you also make a healthy claim, then this rule applies. So there is a rule that is still in effect that allows this claim only if a product meets specific limits for total fat, saturated fat, sodium and cholesterol, and the product also has at least 10% daily value of one of vitamin A, C, D, calcium, iron, potassium, protein, or fiber. That is a very nutrient-focused version of what is healthy that FDA has now moved away from and promulgated a new rule that compliance will be due in February 2028. The rule is in effect now, and you can take advantage of it if your product qualifies and wouldn't otherwise qualify under the old rule. But the focus is now less on specific nutrients and more on foods. So foods that contain only major food group ingredients, vegetables, fruits, whole grains, etc., with nothing else besides water, automatically qualify as healthy. Water, tea, and coffee with less than 5 calories per serving automatically qualify. And then for everything else, it gets kind of tricky. And we are awaiting guidance from FDA to figure out exactly how to know when you qualify. But basically, you would have to look at your formula, look at the ingredients, and figure out if you meet required levels of food group equivalents from the major food groups, and the product can't exceed specified limits for added sugars, sodium, and saturated fats. So it's become more complicated for those kinds of products to figure out if you're eligible to say the product is healthy, and records will have to be kept as to how you figured that out. But hopefully there will be guidance soon that clarify this. Health benefits claims. So there are different categories. If you want to be able to make functional claims about a product that it's beneficial for human health in some way, there's the absolute no, you cannot go into this territory drug claim. And what I mean by that is if you were making a claim that a product is intended to be used to cure, prevent, or treat or mitigate disease, and that's any not normal bodily condition is considered disease for this purpose, that automatically makes the product a drug and an unapproved drug, because drugs in this country all have to go through a pre-approval process that is very extensive with the FDA. So you're not allowed to make those claims at all for a food or beverage or supplement. Anti-inflammatory is an example of a disease claim that you may not think of as a disease claim, but FDA considers that to be a drug claim that you can't make. Then there's a category that doesn't get used very often. You see it mostly in the cereal aisle, but these are health claims that are allowed by regulation. And so there are specific regulations that FDA has promulgated that allow for specific claims. There's the content of the claim is specified, and it's about a food or a component of food reducing the risk of disease or a health-related condition. So I put an example here. Low-fat diets rich in fiber containing grain products, fruits, and vegetables may reduce the risk of some types of cancer, a disease associated with many factors. That's an example. It's wordy. It's not the sexiest marketing language, and therefore these don't get used all that often. Then there's the much broader category that where the rules are looser in that you do not have to get pre-approval from FDA. And these are structure function claims. So this is a claim that a food or a dietary supplement affects a structure or function of the body. So examples, supports immune health, maintains regular digestion, calcium builds strong bones. Those are all structure function claims that are permissible provided you have adequate substantiation to support them. What that means is reliable, competent scientific evidence, not cherry-picked studies, but that the overall weight of good science supports the claim. And as I mentioned before, it's not enough to have science about one particular ingredient if you can't also substantiate that your finished product has the stated benefit. Turning to USDA's organic program, just really quick. Most important thing to know is you can't use the word organic outside of your ingredient list unless you have certification. And certification is available for basically 3 different kinds of claims, right? You want to be able to say that it's 100% organic. That would mean that all of the ingredients except for water and salt are certified organic. Organic without the 100% means at least 95% certified organic ingredients. Or there is a made with organic blank kind of claim where the blank is filled in with, you can list up to 3 ingredients, like made with organic grains, or 3 categories of ingredients. That requires that the product has at least 70% organic ingredients. Excuse me. I'm getting over a cold, so my voice is cooperating somewhat. Made in the USA. This came up in Slack recently, so I just wanted to address it. If you make an unqualified made in the USA claim, that means that all or virtually all of the product is of US origin. So that means it's both manufactured or assembled in the US, but also that all ingredients are domestically sourced. So if that's not your product, the claim needs to be qualified. So an example would be made in the USA with domestic and imported ingredients. Country of origin marking, these are customs regulations for imported products. If a product is imported and the label that consumers see has a US address on it, then that retail package also has to state the country of origin. So in this example, this is salmon that was apparently wild caught in Alaska, but it's product of China. Well, why is that? Because the country of origin is where the product last underwent a quote, substantial transformation. So while the fish may have been caught in Alaska, they were then shipped to China where they were turned into frozen fillets. So that was a substantial transformation of the product, and that makes China the country of origin. Prop 65. So Prop 65 is a state law. I mentioned at the beginning that states can have, in some cases, rules about labeling that are in addition to federal rules. State rules can't conflict with federal rules. They can't make it difficult or impossible to comply with federal rules, but they can have additional requirements. So Prop 65 is a big example of that. California requires that products, and it's not, excuse me, it's not just products, but anything that can expose consumers to chemicals that are on a list of carcinogens and reproductive toxins have to have a warning. So the reason this is such a big deal is because the law includes a bounty hunter provision, which means it authorizes private enforcers, really anyone in the state of California, can enforce the law by serving a notice of violation. And then if the company doesn't comply or settle that violation, filing a lawsuit. For foods and supplements, heavy metals are the most common concern for Prop 65, but there's a lot of other chemicals on the list. And so, there may be other issues like BPA in packaging. Some of the additives used in flavorings are on the Prop 65 list. Aflatoxins, mycotoxins are on the Prop 65 list. There are exemptions for small businesses, and there are other kinds of exemptions too, or defenses, really. What you need to know is that those are basically meaningless. So there's an exemption if you have fewer than 10 employees. However, unless you only sell your product direct to consumer, meaning you on your own website have online sales to consumers in California, or if you're in California, you have in-person direct sales to consumers. If you are selling through any third party, through an online retailer, through a distributor, through brick and mortar retailers, the vendor terms that those intermediaries require you to agree to when you start selling to them almost always require that you promise your product is compliant with Prop 65. And if it's not, if the retailer or the distributor gets hit with a notice of violation, you're promising to indemnify and defend them. And so because of that, it's basically doesn't matter that you are technically exempt, because what the plaintiff's lawyers will do is when they send a notice of violation to a small brand, they will usually include the retailer. Bioengineered food disclosure standard. So this is law. It's implemented by USDA that requires products that contain or bioengineered. So this is what we call GMOs, what most people call GMOs. The terminology in the standard is bioengineered, which USDA believes is more accurate. And disclosures are required. There is a list of commodities, of ingredients that, or food types that are commercially available and as GMO. And if you are using a food on that list, unless you can document that your product was not derived from bioengineering, the disclosure is required. There is an exemption for manufacturers with less than $2.5 million in annual revenue. For everyone else, compliance is required. And mostly this comes down to record keeping, getting certifications from ingredient suppliers that the ingredient was not produced with genetically engineered technology or material. Free claims. So this also came up recently in the Slack, and I wanted to address it. So there is a defined, well, we talked about nutrient content free claims, but when we're not talking about nutrients, when we're talking about other substances in food, there's a defined gluten-free claim, which means there's nothing intentionally added that contains gluten, and the finished product has less than 20 parts per million of gluten, such as from unintended cross contact. Other than that, there are no definitions for free claims. So we often see this with allergens. So I took this example: free from 14 allergens, dairy free. Um, those claims, there's no tolerance established in any FDA regulation like there is for gluten free. And therefore, if there is any trace of dairy or an allergen in this product, that would be considered misbranding. And it's also potentially very risky because the people who are relying on these claims, in part, are people who have severe food allergies. And if the claim turns out not to be true, then potentially people could get severely ill. So you have to be very careful about free of claims if there's any potential risk for cross contact. For other kinds of contaminants, like free of pesticides, free of heavy metals, again, there's no defined tolerance in any rule. So we have to go back to the general principle: the claim must be truthful and not misleading and substantiated. The safest course is don't use that claim if there is any detectable trace of the substance in the product, or if there could be. However, the FTC says that that's not necessarily always required, that for certain kinds of things, there could be an expected background level of some trace amounts of contaminants, and that saying the product is free of that contaminant is not, in that context, necessarily deceptive, as long as it's not at a level that would cause anyone harm. But I would say rely on that with caution. Other kinds of undefined claims. So most of what you see on food labeling is not defined in any regulation. So these could be claims like sustainable, good for you, natural is a big one. Different sorts of dietary preferences like keto, clean, real, simple, right? All these different terms that we see, where you're not going to find a regulation that defines that term. So, general rule, you have to use it in a way that is truthful and not misleading to reasonable consumers. And so I encourage clients, what I'm always doing is to think not only about what you mean by a claim, but what could other consumers think the claim means? Because it's that's often where the problem is that there are unintended meanings that people can take away, or that a plaintiff's lawyer can come up with, which is not what you intended, but at least provides a basis for the argument that people are being deceived. If it's a factual claim, it has to have substantiation. And again, you want to consider the overall impression, then what is the net impression of the label and the advertising, not just the specific claim in isolation. So I've got some examples of fairly popular litigation targets these days. Just to give you an idea of when claims are undefined, how that invites the risk of litigation. Um, so this is an example. There's a claim on these potato chips: no artificial colors, flavors, or preservatives. The allegation in this case, and in many, many other cases that are just like this, is that that claim is not true because the product contains citric acid. In this case, it's sea salt and vinegar chips. Citric acid may be imparting some of the sour vinegar type flavor. Citric acid that's commercially available is generally synthetic, or at least that's what the plaintiffs say, and therefore no artificial flavors is misleading. Also, citric acid can be used as a preservative. And by the way, it's not just citric acid, but most commonly it has been, but it could also be ascorbic acid, malic acid. Any of these multi-function acidulants have come up in this context, where the brand makes a statement about there being no artificial flavors or preservatives, and yet those ingredients are in the product. They're not usually used as flavors, but because they may have an impact on flavor, the plaintiffs argue that's deceptive. So as a sort of more general context of risk, products that are represented as being natural, as not having artificial ingredients, as being 100% anything, 100% juice, 100% whole grain, pure or clean. If they have an intentionally added artificial or synthetic ingredient, well, that's a risk. But even if they have an unintentional contaminant, heavy metals, PFAS chemicals or forever chemicals, pesticides, those are all bases for a lawsuit saying that those kinds of representations are misleading, um, because the product actually isn't 100% pure or clean or natural. I have no idea why there's March 9th, my daughter's birthday, in here, but the emerging theory of a failure to warn is even where there's not been a statement that a product is 100% natural. So there's a case right now against Amazon involving rice products that rice is a sort of known source of arsenic. And so Amazon's being sued for selling rice without disclosing the presence of heavy metals. There are lawsuits that have been filed against protein powders because there was recently in the news Consumer Reports testing finding heavy metals in protein powders. And in part, those suits are based on a failure to warn, material omission kind of theory. Another kind of risk, and this is another example of a real case that's been filed very recently, is this sort of health halo claim, which is, again, as I mentioned before, you may have claims that are literally true or compliant, and I don't know, but this product makes a lot of different claims, and they may all be true. Made with real fruit, presumably there's real fruit in the product. It's plant-based. It qualifies as a good source of vitamin C. It has no high fructose corn syrup, no artificial colors or flavors. Each one of these taken in isolation might be true and compliant. The plaintiffs argue that the net impression of this product, which is called fruit bars, has kind of natural fruit imagery, calls out that it's made with real fruit, with all of these kinds of claims, is that it's a healthy product. And the allegation is that it's not healthy because it contains significant amount of added sugar and basically has artificial ingredients and is essentially no different than any other popsicle. Those are the allegations in this case, and there have been others like this where it's the overall impression of being a healthy product that the plaintiffs argue is deceptive, even though specific claims might be truthful and compliant. And it's particularly a risk for products that have significant amounts of added sugar. Other litigation targets, also a lawsuit that was filed very recently, are broad claims about ethical sourcing. In this case, Starbucks is being sued for representing that it ethically sources its coffee, and the allegations are that that there are not very ethical labor practices in its supply chain. But there have been other cases involving other kinds of representations about fair trade, animal welfare, environmental benefits. So broad environmental claims like sustainable, environmentally friendly can be really difficult to substantiate and therefore make you a target if it turns out that at least part of your supply chain is not sustainable. Recyclability claims are getting increased attention and can be tricky. So those are all examples. I get this question a lot, which is, are the rules different for advertising than for labeling? The safest bet is to just assume no. Assume that everything that I've said about FDA rules also applies in the advertising context, and to use claims consistently across all of your advertising and marketing and labeling. Technically, that's not exactly the case. But the Federal Trade Commission has a policy that it defers to FDA's rules for claims, and as part of its consideration of what is deceptive. In general, if we're talking about functional benefits, health benefits claims, the kind of scientific evidence that you need is the same, whether it's on labeling or advertising. But there can be some more flexibility in advertising. For example, whereas FDA has specific words you have to use to describe the level of a nutrient and no other words are allowed, that's not necessarily the case in an advertising context, as long as the claim you're making and the net impression of it is truthful and not misleading. Also, in the advertising context, you have more space usually. I mean, if we're talking about websites, um, maybe not so much in social media, but if you have more space to qualify a claim, to put it in a context that makes your message clear and truthful and supported, you just don't have that in labeling. And so for that reason, it could be easier. You have a little bit more leeway in an advertising context than you do in a label. Certifications. So certifications are really popular. They're not required except for organic and kosher claims, and kosher labeling is regulated by some states. It's not federal law, it's state law. But other than organic and kosher, you're not required to have a certification. I explained what the standard was for gluten-free. You can say that your product is gluten-free as long as you meet the regulation, but certification goes beyond that, and any certification is representing that the product meets a set of standards. So there is a published standard behind every certification mark, and your use of this logo is signifying to consumers that the product meets that standard. Where people get in trouble is in thinking that the certification allows them to say all kinds of other related kinds of messages that may not actually be covered by the standard. So if you're going beyond just using a certification mark, make sure you have substantiation to support the claim. And then also there have been lawsuits that have challenged products bearing certifications, saying the certification is basically meaningless because it's not really enforced or the standard is too loose. And so overall, consumers are still being deceived. So, some key takeaways I have for you. First, hopefully you get the impression food labeling is highly regulated. There is a detailed set of rules. You can find them, you can read them. I wish I could say they were easy to understand. They're not, and unfortunately, the last time FDA issued any sort of guidance was in 2013. It's still useful, but a lot of it's outdated. So it's not the most user-friendly area of regulation, but just know that there are rules. Assume that what you want to say about your product has some rule that applies or something you need to be aware of. So find out what those things are. Noncompliance does create a significant risk of litigation, other potentially costly consequences. And importantly, compliance with the rules is not necessarily enough to prevent getting sued or other kinds of risks if the label overall is still deceptive. Here's my contact information. Feel free to reach out. I'd be happy to answer questions and talk to you. I think we've got a little time.
There are so many questions.
Oh boy.
I couldn't
Okay.
even interrupt. Thank you. That was 50 minutes of just straight knowledge dropping. There are hundreds of questions, and I really apologize to everyone because there are 253 people on the call at this moment,
Wow.
and so that's why we can't stop and answer all of the questions that come in. But let's pick a couple because we've got 7 minutes left. First one that I think people probably want to know is from Emily. What is the price range to have a lawyer review your labeling?
Oh, geez. Well, so it really it depends, and I'm sure there's a very broad range, right? So, for me, I'd say count on starting at $500, for a label. Um, and it can go up a lot from there. So it depends on how complicated is it, how complicated is the product, how many SKUs there are, how many, how different are the labels across SKUs. Um, it, Starting price for other lawyers will be a lot higher than that.
Okay. So typically when people reach out to you, you're like, okay, how many different labels is it? Are those products really similar? Are they really different? Because then it'll take me more
Yeah.
time.
So let me say this: if you are, it's always good to get this information early in the process, right? So before you even have a label, before you even have a product, like know what the rules are, what you'll be able to say about it, so you can formulate around that. If that's going to be if certain claims are important, right? But when people come to me when they already have a label designed, or at least they know what the content is that they want, they send it to me. I take a look at it, and I have like an analysis that I do. I have a spreadsheet of how I figure out what I'm going to charge for this, because it just depends on the complexity.
Okay. So the easiest thing in the world, one label could be $500 total. And if it gets really complicated and it's a lot of SKUs, probably it can get up to 3K, 5K if it's tons of different lines, all that kind of stuff.
Yeah.
Okay,
Yeah.
cool. Also, you told me once upon a time something very interesting to me, because I worked with a regulatory consultant who did my initial
Mhm,
label review. And then I came to you when something went wrong.
mhm.
And you told me, by the way, just so you know, when you're having a dialogue with them, with your regulatory consultant, of like, well, here's what we want to do. Can we do that? All of that, if you get sued, is discoverable because they're not your attorney, right?
Yeah, that's right. So, non-lawyer consultants don't have attorney-client privilege. So, yes, those communications would be potentially discoverable. It's also that kind of conversation is legal advice, right? So, well, there's a lot of great consultants and like well-meaning consultants and who've been in this space long enough to have opinions about these things. It is really crossing the line to legal advice to be assessing the risks of noncompliance.
Hmm. They typically, in my experience, will only do that on a phone call and will not write that
Yeah,
down. But they're like, you
yeah,
can't do this. And then I call them, I'm like, but like what? And they're like, well, it's really low risk. I'm like, okay. But then one of those low risk things turned out to be high risk.
yeah,
And then I think it also is interesting for people just to understand what can happen. And I can tell you, like, for me, this has happened to me before, where something that we knew there was a little bit of risk there, but it really didn't seem like many people had been sued for this kind of a thing. Um, Somebody sent me an Instagram advertisement from a lawyer
hmm,
trying to find people out there who would
hmm,
sue us for something, which was
yeah,
not my favorite thing about Instagram to see. And then we got a note from them like, yes, you are being like, don't you know that this consumer's life was significantly impacted by this thing that, you know,
right,
tasted a little bit less like this than they were expecting. And
right,
they don't even know where they bought it, but they definitely weren't infected. And then they're like, and then what happens is they're like, okay, you need to tell us what your entire year sales are. Okay, we want
hmm,
like twice that for this person and for you to change this. And then, like, okay, I think we ended up going back to them with like, okay, yeah, I'm so sorry that, like, they may never walk again because they had tasted a little bit less, or whatever. And here's $1,000, please go away. And then they came back, they're like, no, you don't know how serious this is. We want like 100K. And we're like, yeah, maybe like 2K. And then I think we ended up settling for 10 to 20, and then we had to change the package. Pretty common.
yeah, very common. So yeah, the nature of this kind of litigation, by and large, there are exceptions, and the competitor lawsuits, the public interest group lawsuits are different. But the class action litigation generally is lawyer driven. Lawyers who've come up with a theory for a particular kind of violation that they're interested in, a non-compliance issue or deception that they're interested in. They go out and find all the products that they can that fit that scenario, that basically cut and paste a complaint, change the names of the parties, change the pictures of the products, but basically they can rinse and repeat the same thing over and over again. And then they find the plaintiffs to be the class representatives. And, that's not illegal. Um, Maybe it serves some function in promoting honesty in food labeling and advertising, but that's how it works. And it's not uncommon to end up settling at a range that for a startup is still expensive, but less than the costs of even the beginning stages of defending, right? So if you're a plaintiff's lawyer and you can be sending out dozens of these kinds of demand letters every month and getting 20, 30, $40,000 a pop to settle, you're making pretty good money to fund the cases against the bigger companies that fight back, where you actually have to go through protracted and time-consuming litigation.
Yeah. And I know in our instance also, it's like, well, we have to change this, but we know because we're not fighting it. We're not fighting, like making it a class action that we can fight once. Like somebody else could actually come with
Yeah.
a claim about the same thing, but
Yeah.
we're just going to change it and say that it's being changed and change all of the imagery that's online immediately about that, because that's what a lot of people look at as quickly as possible. So we're pretty much hitting time here, but I just want to thank Lauren Handel again for just all of this good stuff. And again, I'm so sorry we can't get to everybody's individual question. It's an impossibility, but if you want to reach out to Lauren, you could do that.
Please do.
She just took off the slide, but it's Lauren@handelfoodlaw.com, right?
Yep, that's right.
I'll just type it one more time here in the chat.
I'm in the Startup CPG Slack. I'm on LinkedIn.
Yes. So thank you very much. I know some people will have really specific questions. I doubt that Lauren is going to take years of her life to answer each of them, but who knows? She might if it's easier, or she might tell you if it needs a consultation or something.
Yeah.
But I love that we are able to attract people like Lauren into the Slack to help people out, because this is a good option for brands that need to be scrappy in the early stage, getting access to people who have just the experience that you want. And we have some big firm partners, we have some small firm partners, and they both can be really good fits. So thank you again. This is our favorite kind of interaction to have, where everyone gets to learn. So thanks everyone for all the questions. I'm sorry we didn't get to, but we still appreciate it.
Thanks for having me.
See you on the next one. All right. Bye everybody.